Okay, I think that we will go ahead. Good afternoon, everyone. My name is Joseph Kearney, and it's my privilege as Dean of Marquette University Law School to welcome you to our annual George and Margaret Barrock Lecture. Let me begin by saying a few words about the individuals in whose memory this lecture stands. George Barrock was a Marquette lawyer from our class of 1931. George's parents were from Lebanon, coming over to the United States on a cattle boat. Like so many immigrants, they both modeled a strong work ethic and stressed to their children the importance of education. Upon George's graduation from law school, he started his own firm in his native Milwaukee. He was primarily a family law lawyer, although he always wished it said, I understand, that he would try to help his client reconcile with his or her spouse rather than divorce, if such were possible. In all events, George Barrock was certainly fortunate in his own marriage. His wife, Margaret, was not only his partner for life, but also worked with him at the law firm on administrative matters. A bequest to support an occasional distinguished lecture in George and Margaret Barrock's memory was provided by their daughter, the late Mary Bonfield. This is that lecture, which focuses annually on criminal law. While this was not George Barrock's own specialty, it is consistent not only with his daughter's bequest, to be sure, but with his own practice, which served individual citizens with everyday legal problems. Moreover, criminal law is an historic strength of Marquette University Law School, certainly insofar as our teaching and our graduates' practices are especially concerned. We are thus very pleased to be able to offer this lecture series, which we can now denominate as annual. Last year we had to say merely inaugural. And we are not just pleased, but we are truly fortunate to have with us today, on the occasion of this second Barrock Lecture, Joshua Dressler. Professor Dressler holds the Frank R. Strong Chair at The Ohio State University's Moritz College of Law. He's a leading scholar of criminal law and criminal procedure. He is well known to law teachers and students across the country as the author of criminal law casebooks, one of which has achieved the remarkable distinction of being adopted at a majority of American law schools. He is well known also to judges, for his articles and treatises are frequently consulted and cited by courts. For example, Professor Dressler is the editor of the 4-volume treatise Encyclopedia of Crime and Justice, and helped to create the very well-respected Ohio State Journal of Criminal Law, which he now serves as co-editor. There is so much more that might be mentioned in introducing Professor Dressler, from scholarly activity, such as his work on proposed revisions to the Model Penal Code, to teaching, as recognized by awards at various law schools where he has served on the faculty. But we are interested in what he will do for us today at Marquette Law School, which is to share some critical reflections on feminist goals to reform self-defense law. That is, to deliver this year's Barrock Lecture. Please join me in welcoming Professor Dressler.
Being short, I'll put it this way. I'm also a Dodger fan, but that won't work here, so I won't. First of all, I want to tell you how flattered and honored I am to have been invited to give the second annual Barrock Lecture. I've had a chance to meet a good number of faculty today and to see your new building that's coming up, which is awe-inspiring to me at a school which could desperately use one as well. And I think it'll be an exciting place for everyone who's here, both as students and alums. It's really a great building. So let me indeed speak to you today about a number of reforms I put in quotes, that have been proposed for the law of self-defense. The proposals I'm going to discuss intend to expand the right to use deadly force in self-protection, to expand it beyond what's currently authorized. And as it turns out, these reform proposals are, to differing degrees, advocated by persons who espouse feminism, or at least characterize themselves as feminists, and who support their reform proposals with feminist rhetoric. Now, in critiquing these so-called, at least, feminist reform proposals, I admittedly do so with some trepidation. First, attaching labels such as feminism to ideas, proposals, or people can interfere with serious discussion, and obviously I don't want that to happen. Also, there are obviously ideological differences or schisms within feminism, as there are with all isms out there, and I don't intend to discuss those distinctions. I'm quite prepared to accept that while some persons who call themselves feminists favor all of the reform proposals I'm going to be discussing, others don't. So if you object to the label feminism being attached to one or another of these proposals, I can't fault you. I could strip the word feminism from the title of this program, but that wouldn't change or lessen the importance of the topic, because it seems to me any effort to expand the legal use of deadly force is something about which we should have considerable concern. I've decided to focus on the feminist aspects of this area because, notwithstanding how my comments may sound, at least at the outset, I consider myself a feminist. I value feminism. So it's a matter of great concern to me when people with whom I normally feel in alliance go in a direction that I regret. But as other scholars have noted, the so-called feminist war on crime has brought us to what may be characterized as strange crossroads in which feminists and law and order advocates seem at times to be, pardon the expression, in bed together. For today's lecture, when I do use the term feminism or feminist, I do so in the very general sense explained by Martha Chamalis in her book, Introduction to Feminist Legal Theory. At this point, I put up some pretty unremarkable PowerPoints, but there they are. You will notice, of course, I've even put the word feminism in quotes. Uh-oh, what am I doing? Oh, yes, I pushed the wrong button. Okay, here's how she writes it. Most legal writers who identify themselves as feminists are critical of the status quo. The root of the criticism is the belief that women are currently in a subordinate position in society and that the law often reflects and reinforces this subordination. Whatever their differences, feminists tend to start with the assumption that the law's treatment of women has not been fair or equal and that change is desirable. Feminist legal scholarship is oppositional. It assumes there's a problem and is suspicious of current arrangements. Feminist critiques of the law can take many forms. They can consist of thick narrative descriptions, causal analyses, or advocacy of reform. And of course, my comments will focus on the latter. All right, one last introductory comment. Feminism, in my view, has enhanced the law by forcing us to rethink all of our presuppositions to determine if we can defend the status quo. In criminal law, most notably rape law, feminist reform efforts have greatly enhanced the legal system. But a lecture about what's right and good is far less interesting and probably far less important than talking about what may be wrong or dangerous. So let me begin with that. I have to start, I guess, with a brief, very brief review of traditional, old-fashioned, if you will, self-defense law. In recent centuries, self-defense has been characterized as a justification defense. That is, that when a person claims self-defense, she is stating that killing the aggressor was the right thing to do, that the result of that dead human being in front of us was a good result, or at least an acceptable result. So when we think about the reform proposals today, we should not lose sight of the fact that by expanding the right to use deadly force, our society would be asserting that greater use of deadly force by persons threatened with harm is desirable, or at least okay with us. Okay, so when is deadly force justifiable? In general, traditional self-defense provides that deadly force may only be used by an innocent person against an aggressor if the non-aggressor reasonably believes that deadly force is necessary to repel an imminent, unlawful, deadly attack. And notice that under this doctrine, if the innocent person can reasonably avoid death using no force at all, then she must use the nonviolent route rather than kill. If she can reasonably